Judicial Service Commission.
Thank you, Commissioner.
Welcome.
Good afternoon, Council. My name is Caroline Zilani. I'm a Commissioner. Karibu.
Asante.
Good afternoon, David Majanja, Judge and Commissioner.
Good afternoon, Maron, and thank you.
Yes, thank you, Commissioners, for that introduction. Council, the honorable members will be engaging you on your application for the position of a judge that you have made, so they'll be asking you questions. We can begin by asking you to confirm your county.
Maridi, I come from Tharaka Nithi County.
Tharaka Nithi. Your ethnicity?
I am Tharaka.
Tharaka. Thank you very much. The Honorable Vice Chair will start us off.
All right. Now, just a few questions. Now, first and foremost, you, as the Honorable Chief Justice, has observed, you were here with us previously when you applied for the same position, and I think I owe it to you on behalf of the Commission to indicate that you performed well. It's only that the positions were limited, and because of the balancing, you didn't make it. So it's not out of, lack of good skills or anything wrong with you. You actually performed well.
Thank you very much.
For purpose of this interview, the fact that you've come the second time is a testimony to the fact that you have some burning desire to join the judiciary.
That
now,
is true.
You need to explain to the Commission what is this burning desire, what informs it, and you be very specific, maybe even to incidences that you'll be able to point out as evidence of that desire to join the judiciary.
Thank you, Commissioner. It is true that I am passionate, very passionate, to join the judiciary and to serve the people of Kenya in the capacity of Judge of the High Court of Kenya. And part of the reason, the mic this way? All right. It looks like that way. Yes, it did. So I was saying that I am really passionate to join the bench and contribute my fair share in the delivery of justice to the people of Kenya, and also contribute to the development of the law. I have been in practice for 29 years now. 8 of those years, my lady and commissioners, have been spent partly in public service. First as a member of the Industrial Property Tribunal, and for 3 years from the year 2016 to 2019, and from 2019 I was appointed as a chair of the Industrial Property Tribunal, and that appointment was renewed in the year 2022. And I think it's time that I close over fully and contribute, because I have had one foot in private practice and another foot in public service. And I think I would contribute more if I was fully engaged as a member of the judiciary. I know there have been a lot of developments, and since the introduction of the 2010 Constitution, and I know the place of the judiciary is a hallowed one in the defense of the rights of the citizenry. And if I'm granted an opportunity, I would contribute my humble share as a person who was educated largely at public expense, at public schools. I think it's time that I came and give back to this society a portion of, we sit as 5 members. And I've learned to improve my interpersonal relations skills, people skills, so that then I can guide the tribunal in a manner that will then help us achieve our goal in expeditious delivery of justice. The other skills I have learned is proper time management and active case management. Meridian commissioners, the rules relating to the practice at the Industrial Property Tribunal are very generous in terms of the timelines for filing of pleadings. Unlike in ordinary courts where one is required to respond, say, within 14 days after being served. In our case, one is required to respond after 45 days. And once they file their response, the other party is also given another 45 days to file a reply, if any, or if they are not filing a reply, then they file evidence in form of statutory declarations within another 45 days. And the respondent will also be required to file, after service, to file their statutory declarations containing the evidence after another 45 days. So this has proved a big challenge in getting a turnaround before close of pleadings and the matter is ready for hearing, within which to comply. And once they comply, then we give a date for hearing. Because of that intervention, we have managed to clear the backlog at the Industrial Property Tribunal, and all the cases now that we are handling for the current year are within 1 year, those cases that were found in 2023. And even those ones, in fact, we have concluded 2 of them, and the others are lined up for conclusion, and we hope to finalize before end of April, so that hopefully by June we'll deliver judgments.
A final question.
Yes.
And you know, this is not anything personal to the community. I noticed that if you call Atharaka Meru, they get very agitated. Actually, before I didn't know, I used to think Merus and Tharakas, you know, one and the same thing. Now, and I had an occasion to, for the first time, travel to the county, the deeper parts of county, areas of Marimanti and all that, which actually made me realize. At one time I was asking myself whether it's still part of Kenya. It's very deep and I would say more or less marginalized, actually. I think Matharakas, unlike, you know, Merus, would be marginalized. Now, the question is, as a Tharaka, that experience of coming from those hardship areas, so to speak, I'm assuming you're not from the better part of Tharaka.
Actually, I come from Marimanti. If you
Yeah.
went to Marimanti, that's
Yeah.
I was born in a village called
Okay.
Maroreria, in between Marimanti and
Yeah.
Gatunga.
Yeah. So I want to address you now on that, because
Yes.
even the climatic conditions, I was shocked to learn that women who are jailed in the Meru area, they hardly survive. They even die because of the change of weather. Now, how has that experience of coming from that kind of an area, how would you use that experience, firstly, when it comes to issues of access to justice? And secondly, in terms of informing your philosophical foundation as you develop the legal jurisprudence. And in answering those questions, Please make it very brief because of time, because my colleagues also have questions to ask you.
Okay.
Thank you.
Very well. Let me start by saying that if you asked me, if you called me a Meru, I would not take offense. Probably I would explain to you why you are incorrect in calling me Meru. But we have an experience in this country of marginalization, and it's part of the reason, for instance,
Yes.
this is property that has been acquired by husband and wife, especially during their marriage.
When you say especially during their marriage, what does that mean? Is that to say even property acquired before the marriage is also part of the matrimonial property?
It's not exactly part of the matrimonial property, but you know, my lady, when people get married, there are no divisions. One of the things that my father told me is that when you get married, whatever you acquire and whatever your wife acquires, these are joint properties for both of you for the use of the family. But coming to the issue of law, I know that there is a desegregation of properties acquired before marriage. They belong to the spouses, to the man or the woman, the case may be, as part of what they bring on the table. But properties jointly acquired in marriage, where both the parties contribute to the acquisition of such properties, then that would go to form matrimonial property.
Thank you, and I appreciate the custom. But as you rightly point out, we are now talking about the law in this country that applies to all of us. What about land that you inherit as a taraka from your father and you subsequently marry? Would that be part of matrimonial property?
It will not be part of matrimonial property, but in case of, if I predecease my wife, for instance, she would be entitled to inherit that property.
All right. And finally from me, just following up on that question, what is a matrimonial home?
Matrimonial home would be where both the husband and wife have set up for themselves, and it's just like a nest. This is where we bring up our children, and basically it's our center of operations as husband and wife.
Thank you. Thank you very much. That's all.
Thank you. I think your father taught you well.
Thank you,
if
my
the
lady.
trust
Yes.
continues, that's a good approach, so that you can have harmony in the family.
Yes.
Now we'll move on to the interpretation and application of the Constitution. That is going to be one of the areas you will be engaged with if you become successful in your application. I want you to tell us whether you are aware of certain statutes or certain provisions of the statutes that have been declared unconstitutional, and why.
Statutes or provisions, my lady?
Either of them.
Yes.
Yeah.
I know, for instance, there is a provision in the Law of Succession Act which says that, you know, a wife has only a life interest in
Articles 25 of the Constitution, and this deals with declaration of persons who are guilty but of unsound mind and detained in prison under the president's pressure. So I want to hear from you, how would you help in the administration of justice when you are a judge and you are encountering these situations, especially these persons who continue to be judged and they are persons of unsound mind?
My lady, it would be unfortunate to convict somebody and even sentence them to jail if they are of unsound mind, because the primary element of being in control of their faculties and intending to do the criminal act, they don't have that facility. I would think that those are people society should be more considerate about, and they should be rehabilitated, taken to hospital and things like that, so that hopefully the challenge that they have can be addressed. They don't belong to jail, and especially at the pressure of the president. Yes.
Thank you. Justice Mariaja.
Thank you very much. First and foremost, I would just like to say I've had the privilege of hearing appeals from your tribunal. It falls on my responsibility, and I can say with confidence that I've upheld all the decisions made by the tribunal. Of course, that's not to say I'm right. In constitutional adjudication,
Yes.
in adjudicating constitutional matters, there is a doctrine of avoidance. Just explain why it is, what it is, and why it is an important doctrine.
Avoidance. I'm not familiar with it.
Not familiar with it?
I'm not familiar with it.
Okay.
Probably, does it go under another name?
It's a doctrine of avoidance, or let's say restraint. Let me put
Yes.
it there. Yes.
Yes.
Let's say judicial restraint.
Yes.
Why is that important? Yes.
It's important in constitutional law interpretation. Because for instance, if you are declaring an act of parliament unconstitutional, one would have to be very careful, because there is a presumption of constitutionality. And unless one is careful, if one is quick to declare an act of parliament or sections of the law unconstitutional without satisfying certain criteria, like for instance, is the purpose of the law as formulated by parliament one that is in contravention of the Constitution, for instance, all its effect when you come to implementing it, does it effect, for instance, take away fundamental rights of citizens?
Because I note all the 5 are tribunal decisions, and you sit as a panel. So it's signed off by 3 members.
We sit as a panel, so we don't have individual decisions because the scheme of the Industrial Property Tribunal Act and rules is such that our decisions are collegiate. They don't invest in a situation where we have separate decisions and, you know, like dissenting decisions and things like that. So if I, probably the only thing I would have brought, it's not decisions, unless I brought submissions that I have written in the course of my private practice, but not decisions at the tribunal.
Okay, so but you have your submissions, you do submissions,
Yes,
you do
yes,
pleadings.
yes, 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 yes.
Yeah. Because now you see this one, when we invite another member of the panel, they'll say, I'm the one who wrote it. So just trying to understand if it is your writing 100% or each member give their views.
Well, members give their views, but I play a fundamental role in guiding the way, especially judgments are written. As the Commission will note, I have undertaken studies with the World Intellectual Property Organization Academy. And I have a bit of experience and expertise in the area of intellectual property law.
Okay, and do you have an equivalent of a CUC for this tribunal? Because I remember I asked you the same question last time.
You asked me the same question.
Yes.
Yes.
In terms of outreach and having members of the public get to know about the existence of the tribunal.
We do. In fact, was it in February or January? But we work in collaboration with the Kenya Institute of the Kenya Industrial Property Institute, KIPI. Like the incident I'm talking about, they invited us to participate in a forum, a one-week forum that they had organized for universities and TVET institutions, so that to synthesize members of the public and those upcoming innovators on what they need to do to protect their rights, to avoid the kind of situations that Commissioner, you are writing the last time, that people are stealing citizens' ideas or creations because of lack of awareness. So we are partnering with them, and in fact last week we also had, was it last week?
Okay, I'm
Yes.
okay with that
Yes,
response.
yes.
Have you heard of the Witness Protection Agency? And if yes, are you aware of what orders the court can grant to protect a witness other than camera hearings?
Well, other than camera not disclosed, two, they are placed in areas that after they have been harmed, after the evidence has been given, then it will be very difficult for those different identity and that kind of thing.
And the first bit of the question, whether you are aware of the Witness Protection Agency?
I am aware of the Witness Protection Agency, so probably what the court would then do is direct the agency to carry out certain things that would ensure the safety and protection of that particular witness.
Okay. My last question is with regards to precedents, there's been hue and cry, especially from members of the legal fraternity, with regards to courts issuing contradictory or overturning decisions of coordinate courts. If appointed a judge and you find a decision that you don't agree with, a decision by your fellow judge at the High Court, what consideration will you have before disturbing the existing jurisprudence?
Yes, thank you, Commissioner, for that question. I will look at the law and the Constitution. Contrary to the law and the Constitution, then I would respectively, go a different path from that taken by my colleague judge. Because we all make mistakes, and probably line of reasoning.
Which one we have mentioned that it's mistake? So you
Yes.
say there is the element of mistake. Any other that you think of?
If
why
it
you
is
would deviate?
outrightly contrary to the law, or it was taken without
Okay, thank you. Thank you, Chief Justice.
Thank you. Thank you, Honorable CJ and Chair of the meeting of the JSC. Council,
yes, my lord.
I have worked with you for a long time, from private practice, from the time you were doing the Oregon Quatch. Probably, I don't know whether you are part of the group that came from HHM.
No, I am not part of the group.
Yeah,
that
but
came
then
from
all I'm trying to
HHM.
say, I've known you, and I know your work as a legal practitioner, and now I'm up to date of what you've been doing since I was also last in practice. In fact, I believe, if I'm not wrong, one of your partners was also part of my law firm, if I'm not wrong.
Yes,
Yes,
my
so,
lord.
So all I'm trying to lay down is I know you, so I'll not ask you many questions.
Thank you.
Today I've learned about the misconceptions or misperceptions about Tharaka-Nithi. The first one is that equally like him, Mr. Mashira Njeru, we thought that they are one and the same like Merus. We stand corrected too. The other one, there's another perception which I don't know if you know about it. Some of us who watch elections keenly always know that the last elections usually come from a place called Tharaka-Nithi. The elections from there are always delayed. And sometimes we are concerned. So sometimes we thought, they are cooking something there. Now I do understand that it's because of the remoteness. That is very far.
It didn't.
That you are disadvantaged.
That my round is correct. Like actually, why we get national notoriety because of the statement.
So it is the issue of access.
Yes,
you are very
because
far
of access.
and you are not reachable.
Yes.
So tell me about the access to justice in Tharaka-Nithi.
Well,
or lack of it.
Lack of it. We have a long struggle. We have a court at Marimant, and I think it's manned by a principal magistrate. We could do well because Marimant, is in central Tharaka, and there are far-flung places where, especially in the north, people really struggle to come to Marimant. But obviously, it's a lot better than when they had to travel to Meru, Nkobo, or Chuka. So I think can the judiciary do more, better? I think it can do better. They have done well in getting the court at Marimanti, but if we had more court stations, it would really help.
Okay, thank you, and thank you for the good work. I wish you all the best.
Thank you, my lord.
Thank you, Honorable Chair. I have only one question for the Council. The independence of the judiciary is guaranteed by the Constitution.
Right.
But again, there is what we call the whole of government approach. So would you just unpack to us that statement, and how would the judiciary, you know, execute its mandate, but having in mind the whole of government approach?
Yes. Thank you, Commissioner. It is true that the Constitution guarantees the independence of the judiciary, especially in the area of decision making, so that when a judicial officer is sitting to determine a case, then they should only be guided by the law and the facts of that case, and they should only be subject to the Constitution, and they are not subject to control of outside forces, even though they are part and parcel of one unifying government. Remember, the judiciary is one of the arms of government, but an important arm. So I think the challenge has previously been, and probably it is to be expected in democracies, sometimes there would be misunderstanding about the various roles one is expected to play, but there's no way the judiciary can operate, you know, without some level of interdependence and cooperation, especially in coordinating certain activities with Parliament and even the executive. I think the idea would be to ensure that when this is being done, then the respective mandates of the various institutions are clearly understood, and whoever is engaging then understands that, well, we are engaging because we are serving the same people. But each one of us has a different mandate, and we need to respect that mandate.
Thank you, Chair. Good afternoon once again.
Good afternoon, Commissioner.
Now, maybe you could just tell us briefly about your law firm.
Yes.
The law firm in which you are a managing partner. How many associates, how many partners are there?
We are 2 partners, and we have 1 associate at the moment. Yes.
And the rest of the staff, how many, roughly?
We have 3 support staff. We have 3 pupils.
Oh, okay. And what is the workload like?
Well, it's quite substantial, I would say. Enough to keep us busy. Yes.
Okay. Do you have a performance appraisal system in the firm?
We don't have a written appraisal system, but we have we have a system in place. For instance, we record when a case is opened, for instance, and we are bring up system to follow it up to conclusion, and we endeavor to conclude those cases as quickly as possible, both for the benefit of our clients and also for our own benefit, especially in litigation. Commissioner, you may know, clients will not pay you unless a matter is concluded, especially corporate clients.
But do you think it is important to have a system that at least shows the targets that each employee is given?
It is important.
It is important. Why do you think it's important?
It is important because then it makes you efficient, and you work towards achieving a certain goal. Especially when it is documented, and you can have regular meetings to evaluate whether what you set to achieve has been achieved, and if it has not been achieved, what challenges are making that impossible.
Okay, thank you for that.
Yes.
The second question I want to ask you is based on Article 159 sub Article 2C of the Constitution.
Yes.
DR, do you know of?
Well, there is indeed, and
I saw that, yes.
I have under the privilege of, conducting mediations, the court annexed mediations. I try to support the judiciary, and in that way, and it has been helping. The other one, of course, is arbitration. I also do a bit of arbitration work. Then we have there are traditional methods of settling disputes, and there could also be conciliation and negotiations. Yes.
Okay. So could you tell us the difference between arbitration
Yes.
and conciliation?
Yes. Now, arbitration, first and foremost, parties must agree to go to arbitration. They would have to have an arbitration clause in their agreement.
I was looking more to, about the process.
The process.
Yes. What is the difference, the main difference between the two processes?
Conciliation, like in labor matters, is usually institutional based, but sometimes it can be ordered by courts. Like I think, if I'm not mistaken, in the ongoing crisis, doctors' crisis, I think a recommendation has been made that they go for conciliation through a set mechanism. On the other hand, arbitration is a system that parties have agreed to go into.
We are going back to the same thing about the clause.
Yes.
I'm just talking about how you conduct the process.
How you
what
conduct
goes
the
on in an
process.
arbitration,
Yes.
so that you differentiate the two processes.
So, all right. Yeah. Once the way you kickstart the arbitration process is you write to the other party, ask them to agree to the appointment of, say, an arbitrator in accordance with the arbitration clause whenever a dispute has arisen. Now, if they agree, you can agree on a particular, you can suggest names, for instance, which it is open to them to either accept or suggest their own names. In some arbitrations, arbitration clauses, they say if both parties are unable, for instance, to agree on the appointment of one arbitrator, then some organization like the Chartered Institute of Arbitrators would you can write to them so that they then nominate, appoint.
So what is the difference? What happens in conciliation?
Conciliation, it would have to be like the ones that I'm familiar with in labor relations. They would have to be initiated by probably an institution like or a person in authority, failing which probably the court itself can, in certain cases, order conciliation if there is provision for it in the law.
Okay, let me take that. Thank you, my lady. I wish you well.
Thank you.
Yes, thank you very much, Wakile. Now, the Constitution emphasizes certain characteristics for people in responsibility, responsibility of leadership. In Article 73, it talks about responsibilities of leadership. Can you mention some of those responsibilities of leadership?
Yes, I can mention that leadership is a position of trust, in that it is to be, that position is to be exercised for the benefit of the people. And because it's a position of trust, one should avoid situations that would lead, for instance, to conflict of interest. One should, if you see that you are conflicted, then you would be duty bound to disclose. And like in the case of a judicial officer, then once I disclose, I would have to recuse myself, or yeah, I guess, so that that matter can be handled by somebody else. The other principle is that whatever I do should not demean the office that I hold, and I should have respect for the people. I should always conduct myself in a way that brings honor and dignity to the office. And I should always have the presence of mind to know that the office I hold, it's an office to serve and not lord it over the citizenry. And what is more, I would have to be objective and impartial in the decisions that I make. I would have to be accountable to the public. For instance, if I'm conducting a case, I need to go to court early, for instance. If I make a decision, I need to explain why I am making those decisions.
That's okay, Council. Thank you.
Welcome, Commissioner.
Thank you, Honorable CJ. Council, you have been in private, largely in private practice for over 28 years.
True.
And now you want to join the institution of judiciary. Maybe, and I know you've you've given much thought to the position and the challenges that come with it. Maybe you could tell us 3 challenges that you think judges experience on personal levels.
Well, one of them is balancing work and other personal responsibilities, especially family. It can be very difficult sometimes, and one would have, for instance, if I am appointed, I will probably be posted in a place like Bungoma or Kisumu. I would have to leave home and be basically there most of the times. So my family members would have to be meant to understand, look, life will not continue the way it has been in the past.
And that is one.
The other one, of course, one faces is sometimes because the decisions that you make in an adversarial system will not please everybody, then you become a target for sometimes very negative and sometimes public attacks, and because judges are human beings, obviously this affects them. So one probably has got to develop a very thick skin and to know that it comes with the territory.
Okay, and the third one?
Now, the third one is heavy workload. Heavy workload, for instance, if you have a course list of 60 cases in a day, and the day is limited to 12 hours, and even out of those 12 hours, you know, the working hours are even shorter, and you're also a human being, you get tired. So unless one is careful, one can experience burnouts. So I think it would be important for one to create time occasionally so that you replenish your energies. Otherwise, you can die on the job, and it won't be beneficial either to you or the public.
Okay. Having been in private practice, like I've said, for 28 years, and being in some levels of comfort, now with the challenges that you've given me, is this a challenge that you're ready to take up? And are you prepared for it? So that you're not coming and it becomes a shock to you.
It wouldn't be a shock to me. I am psychologically prepared. I have also, even it's not exactly where I work, it's not also a place that doesn't have certain pressures, by the way. Practice of law, especially litigation, comes with a lot of pressures, deadlines to meet. Clients sometimes may be unhappy about the outcomes of their case, and you have to explain to them. So there are all these pressures, and I think having practiced law for, it's now actually 29 years, this April, 27th of April this year, I will have done 29 years. But besides, so I have had to, even within the law firm, I have had to try and manage my time in such a way that I will create time so that I have a good work-life balance. Because unless one achieves that, then it will be very difficult to deliver justice even to the people.
Okay.
Yes.
Thank you very much, and I wish you well. Thank
I'm
you,
grateful.
Honorable
Thank
CJ.
you.
Okay.
Thank you very much, commissioners, and thank you very much, council, for this very interactive engagement, and for availing yourself for this interview for the second time. I think also, coming from Meru, I should thank you for clarifying that the marginalization of the people of the Raka has nothing to do with the Merus.
It's true.
It is just the harsh conditions of that area that I think Kenyans realized when they now came up with a devolution, so that resources are devolved, and also there is the equalization fund to make sure that that area is brought to the level of the rest of the Merus. Otherwise, we coexist very well, like brothers and sisters.
It is true.
Yeah, so thank you very much. And now I think this brings us to the end of the interview. On behalf of the Commission, I thank you and wish you well. We also give a candidate an opportunity to ask us a question, if you have any.
Well, my lady, I don't have a question. Mine is to express my sincere gratitude for affording me this second opportunity to appear before you, and submit myself to the interview for this position of Judge of the High Court. I don't take it for granted. I know we were very many, and for me to have made the cut a second time, I am truly grateful. Yes.
Thank you, and I wish you well. We will get in touch with you when we complete the exercise. Give our greetings to your tribunal, and keep up the good work that you're doing there, and also in your practice.
Thank you, my lady.
All the
And
best.
thank you, Honorable Commissioners. A very good afternoon.
Thank you.